Hello, this is Dr. Advocate Sheetal Babar. In this session, we shall be discussing about construction of a will. Now, will should not be a new concept to us because in our earlier session, we've already discussed what is a will, how it is defined under Indian Succession Act, how do we differentiate or classify wills in a few kinds, how do we execute a will, and what are the legal requisites for execution of a will has already been discussed in the earlier session. So now in this session, we shall be just focusing on how a will to be constructed. Are there any sections or is there any part of Indian Succession Act which gives honorable courts as well as we as a layman or maybe legal practitioners or budding lawyers or students, are there any directions given to us to construct a will in complexities? The answer for this is Chapter 6 of Indian Succession Act gives us all of these directions and give answers to many questions which might pop up inside our brains and minds while constructing a particular will. Though Chapter 6 in toto discusses all of these detailings of construction of a will, as per me, there are few sections. After reading these few sections, we get a clear cut idea as to how the will is to be constructed. And in this session, we shall be just focusing on those sections. So we will be more focusing on sections 82 to section 88. We shall be going into details of all of these sections wherein we find the answer how the will is to be constructed in complexities. So let us start with section 82 of Indian Succession Act wherein we get an idea as to how meaning of a will is to be construed. Section 82 talks about how we give a meaning to the will. The statements or section 82 specifically states as to the meaning of any clause of a will is to be collected from entire instrument and all its parts are to be construed with reference to each other. So if in case there are many parts of a will, you cannot part them up entirely and construct them separately. You have to take up all of these parts as a collection and read them in toto, entirely interpreting the whole will. Then you get an idea, clear idea as to what the meaning of this will is. So there are two things explained under section 82. First is you definitely can classify a will into parts. You can read them part wise. However, first condition what section 82 speaks about is after reading parts of the will, you have to collect them entirely and read them as an entire instrument. And secondly, section 82 gives us a condition that after entirely reading this instrument or entirely interpreting this instrument, you have to construe the meaning of each part only with relation or in relation to all other parts. You cannot have part 1 is separate from all other parts. So, collectively reading the entire instrument and construing it with respect to all of the parts are two conditions basically imbibed under section 82. Let us go on to what is section 83. Section 8 speaks about a situation where sometimes testator might have used words and how those words are to be interpreted. Because when it comes to will is basically built up with many number of statements, many number of words. And then how do we interpret all of these words in these many parts? So, whether testator's intention is to use a word specifically in a restrictive sense or in a broader sense is the answer given under section 83. It states as to once You read the entire instrument collectively with all different parts relating to each other. You get an idea as to whether a testator wants to use particular words in restrictive manner or in a broader manner. So say for example, A is a testator who has made a will in which in first part he has written that his houses shall go to B after his death. And in later part of his will, he has specifically used a word, and the farmhouse shall go to C after my death. Now, in this situation, there are only two houses of this testator A. One is the dwelling house and another is the farmhouse. When we generally use houses, houses is the word to be used in a general sense or a wider sense. However, if you just read part 1 of this will, you are quite clear that both of the houses, the dwelling house and the farmhouse, will go to B. However, it is very specific in part 2 of the will of testator A that the farmhouse which he owned shall go to C after his death. Now, reading section 83 along with section 82, we will get an answer that word houses, though used in plurality, because he has houses. One is the dwelling house, another is the farmhouse. So plurality of this word houses can be construed in a restrictive manner, reading part 1 and part 2, and effect can be given to the first bequeath, that is to B. The dwelling house will be given to B, and next is to C, it will be the farmhouse, because here the testator wants to use houses in a restrictive manner. He is specifically talking about after entirely reading the whole will. If you read it in part and you don't take section 82 for interpretation, you might interpret that both of the houses will go to B. However, reading the entire will and giving effect to section 83 as well as 82, we know that the testator is intending to give his dwelling house to B and farmhouse to C. So that is how whether the words are to be used in a restrictive manner or in a broader sense is what section 83 details about. Let us go on to what is section 80. Section 84 talks about where under a will there are two possibilities of constructions and then which is to be preferred. As in I just mentioned that there might be many parts in a will. In the first part of a will there is something which we can give effect to. In the second part of a will there is something which is enabling us to give effect to that first clause. So what to do with this? Whether to go with clause 1 or part 1 or clause 2 or part 2. So this answer is where we find under section 83, wherein it has been specifically stated that if there are two possibilities under a will where one part is giving effect to something and other is giving none, in this situation it is always the earlier to be preferred because at least it is giving effect, and that is how it is the way for intentions of the testator to give effect to his or her will. And hence if there is a possibility of giving effect or restricting effect, giving effect is something to be preferred as per section 84. Now let us talk about section 85. Section 85 says no part rejected if it can be reasonably constructed or construed. So, no part of a will shall be rejected as a destitute of meaning if it is possible to put a reasonable meaning to that particular part of the will. So, 84 and 85 go hand in hand. 84 talks about two situations wherein one situation is giving effect after construing that part. After interpreting second part, it is taking away the effect. In this situation, we definitely are going to prefer the clause or the part of the will which is preferring giving effect to the will. Section 85 is also onto the same footings. It talks about there are two parts amongst which one is trying to give effect and one is rejecting to give effect. In this particular situation, what shall we do, or what shall honorable courts will do, is they shall, instead of using uh, any part which is not giving effect, they shall construe it with what we call as a golden rule. So it shall be effected by construing the part which is giving effect or which is giving meaning to that part of a will, and hence giving effect to the entire instrument. That is what section 85 speaks about. Let us go ahead with further section 86, which specifies about repetition of certain words in different parts of the will. As we know, will is something which has many parts, which might have many parts. So in such situations, there might be many repetitive words. How to construe these words? How to interpret these words? Unless and until there is any contrary intention of the testator to use that word in a different manner. Section 86 gives us a detail about using that word always in the entire will on the same footing or in the same sense. So, any word which has been repetitive shall be construed or interpreted as per section 86, read along with section 83. Why? Because if there is something which is giving a stricter or restrictive meaning or a wider meaning is absolutely upon the intention of the testator, which we've already studied under section 83. And now section 86 says if it is unless contrary intention is apparent of the testator, then these words shall be construed in the same sense for the entire instrument. They shall not be construed in different ways because they are present or repeated in different parts of the will. They shall be construed on similar sense. That is what section 86 speaks about. Let us see what the section 87 of Indian Succession Act gives us an idea to construct a will. Section 87 details about effectuating the intention of testator as far as possible. Now, what does this mean? Let us take an example. A is the testator who is on the deathbed. He stated that his whole property shall first be devolved or bequeathed to C, after which the property shall devolve upon D, and then the property shall belong to E forever. However, while doing so, A wasn't having any idea that E has predeceased or E has expired. Now, in this situation, just because E is not present in the survival frame doesn't mean that property devolved upon B and C are not to be effectuated. Section 87 gives us the general idea, or let us say it as a specific idea. It states, as far as possible, the will is to be effectuated, or rather, testator's intention needs to be effectuated. So, wherein we know under the illustration given by me, E is the one who is not surviving A, but that was not within the knowledge of A while he was on the deathbed. And hence, the property shall devolve upon B and C. So this is how we give maximum interpretation and maximum effect, because intention of the testator is always positive towards effectuating his or her will, and that is what the duty levied upon the honorable courts as well as we as the lawyers, to find out a way only for giving effect to intention of the testator. And that is what section 87 gives us an idea or specifies about this idea. Let us go ahead with section 88, which is the last section for this discussion, and then we move on to the case laws, wherein we say what honorable courts have discussed about all of these sections. Section 88 of Indian Succession Act discusses about a situation where there are two inconsistent or irreconcilable clauses which cannot stand together. So say for example, A has bequeathed in part 1 of his will all of his property to B, and in later clauses he has specifically mentioned that all of his property shall go to none but to C. Now here, even if we apply golden rule of interpretation, we understand that these two clauses are quite contradictory to each other, because first clause specifies the whole of the property, or specifies the intention of the testator that whole of the property shall be devolved upon B. However, last clause of his will, or maybe later clause of his or her will, specifies that the property shall go to none but to C. Now, in this case, we take a help of section 88, where it says, in case where you cannot reach the golden rule or you cannot apply the golden rule, then you have to construe in such a way that later clause shall prevail over the first. And why is this so? Because if you read clause 1 or part 1 of the will of the testator, it is also the one which is giving effect to something. It is also testifying intention of the testator. Clause 2 or part 2 of the will or later part of the will also is in a condition so that the will can be effectuated. Now, even if we try to construe both of them together, read both of them together as per all our earlier sections, it is quite impossible, because both of these clauses are inconsistent to each other. Then now what in this situation? In this situation, it is section 88, which says that it is a settled principle that later clause shall always prevail over the earlier one, where there is a situation of effectuating the intention of a will in both of these clauses which are inconsistent to each other. Only in this situation we say section 88 can be attracted. Now let us go ahead with what all principles as per all of these sections from 82 to 88 have been interpreted or have been applied by honorable courts in respective situations. Now, how basically a will is to be constructed? The answer for this question simplifyingly is given under Anil Kak versus Kumari Sharda Razi. In this case, the Honorable Court has simplifyingly stated a simple principle. It is stated that wherever it is doubtful about the intention of the testator as to how the will is to be given effect to, the court puts itself, or the court can put itself, or rather the court shall put itself in the armchair of the testator and find out the intention of the testator as to how the effect to be given to the respective will in entirety. So the armchair rule, that means putting self into the armchair of the testator, is a very basic principle usually and averagely applied by all honorable courts at respective circumstances, and the will is usually construed in that manner. In another judgment, Raj Bajrang Bahadur Singh versus Bakhtar Kuwar, in this case, the Honorable Court has given us more elaborative principle. It states true intention of the testator is to be gathered by reading the will as a whole. That is what we've already seen in the theoretical part as well. However, this intention is to be gathered with reading of all of its provisions and ignoring none of them just because they are redundant or contradictory. So, even in case if there are any contradictory clauses or redundant clauses in the will, in any of the parts of the will, there is always a way out. And what is that way out as per the judgment of Raj Bahadur? The whole will is to be read in entirety. The intention of the testator is to be construed, and that is how the effectuation or effect is to be given to the will of the testator. In Ramchandra Shenoy versus Hilda Bright, this is one of the landmark judgments, wherein the Honorable Court has stated that it is one of the cardinal principles of constructions of will that to the extent that it is legally possible, effect should be given to every disposition contained in the will. Now, what does this mean? In our earlier part, we've taken an example of A, the testator, bequeathing his property on C, D, and E, while he doesn't have any knowledge of E being predeceased. In that case, maximum effect is to be taken to effectuate the will. So your bequeath to B and D definitely will be a way to effectuate the will or intention of the testator A. So there cannot be something um, contradictory statements, or maybe the statement which cannot come true as to the property to be bequeathed to E is not possible, and hence the whole will is void. No, no, as per Ramchandra's case. The Honorable Court has specified the principle as to maximum efforts are to be taken from court's part to effectuate the intention and dispose of the property the way the testator wants to dispose or bequeath. In Venkata Narasimha versus Parthasarthi, we go beyond this question of just effectuating or giving effect to the will. Now, courts, while discussing as to how to give effect to the intention of the testator, we've seen that entirety of the instrument is to be considered, the will is to be read in entirety or as a whole, and then intention of the testator is to be construed. But in this particular case, in Parthasarthi's case, the court goes beyond just wordings of a will. It has been stated very specifically under this case as to um, the courts are entitled and bound to bear in mind other matters than just or mere wordings used in the will. They must consider the surrounding circumstances, that is, position of the testator, his property, his family situations, his family settlement, etc., has to be given consideration while giving effect to his will, and not mere words used in his will. The court is entitled to put itself in the armchair of the testator. So, what we have seen till now was just construing the words, effectuating the intention through these words, reading all of these words in entirety. But now, under this particular case, we go beyond this paperwork and we find out the circumstances of the testator. And for what? To just find out what the intention of the testator is. So we go beyond this piece of paper and we find the circumstances as to how the relations of this testator, for example, are with all of the beneficiaries of the will. Is there any suspicion which is created because of these circumstances? And then only putting self into the armchair of the testator, effects to be given to the intention of the testator. So not only reading the words and interpreting the words, but interpreting and construing the circumstances beyond the piece of paper is something which was accepted as a principle under Venkat Narasimha versus Parthasarthi's case. Now, wherein we talked about two situations or two possibilities of construction which is to be preferred. Say, for example, section 84, when we discussed about two different interpretations into different parts, so which to be given effect to. In this situation, we have an answer. Now, there might be a situation basically that one part of the will is giving a way to construct the will, and apparently that is clear intention of the testator to dispose of his property in one manner. But there might be another clauses in the will which obstructs or restricts that intention. So there are two possibilities to construct. One clause is giving effect to the intention of the testator through his will, and one part is actually ineffectuating the will. So in this case, what is to be done is answered in Ramkishore Lal versus Kamal Naren, as well as in Radha Sundar Datta versus Muhammad Rahim. In both of these cases, we have similar judgments and principles laid down by Honorable Supreme Court. It states where conflict arises between one part and later part, wherein first part or in earlier part the bequest is absolute, but in later part it cannot be effectuated because dilution by the contrary directions. In this situation, it is always the one which gives effect to the will. So, in this situation, the earlier clause was absolutely the one which gave effect to the will, and later was the one which obstructed or was the one which diluted the very intention of the testator. Sure, honorable courts have gone against Section 88, which is very specific that in cases where are two contradictory situations, the later shall prevail. It's been already discussed in under Section 88. However, Ramchandra's case as well as Radha Sundar's case are very specific because the very general principle of a will is to give effect to the will instead of reluctant to give effect to the will. And hence, sure, we go beyond the sections of Indian Succession Act and we more focus, or honorable courts more focus on natural justice, wherein the intention of the testator is to devolve or bequeath some property or all property of his on someone or on a particular individual. So that is what we talk about section 84, which specifies two contradictory situations wherein which clause is to be effectuated. The clause which gives a positive meaning and clears the intention of the testator is to be given effect as per Ramchandra's and Radha Sundar's case. To sum up with all of these case laws and judgments, let me give you one significant, important, and a landmark judgment which actually talks about all of these situations which we have discussed in all different cases and case laws. We have Pyarelal versus Rameshwar Das. This is the judgment which has recognized few principles on which a will can be construed or interpreted or can be effectuated. It gives us five basic principles. It states intention of the testator by reading the will as a whole and giving to every expression some effect rather than rendering any expression as null or inoperative should be considered. So first principle is something which is giving effect to the will should be continued with, construed with, interpreted with and headed towards, instead of reluctantly cutting down the dispositions or bequeaths intended by the testator is the first principle. Second principle is words accruing more than once shall be presumed to be used always in the same sense. So we've already seen this under theoretical part as well, that wherever there are usage of more number of times of same word, then it shall be construed in the similar way or in the same sense, which is also upheld in Pyare case or Rameshwar's case. Third principle is all parts should be construed only with relation to each other and cannot be construed separately. Fourthly, courts will look at circumstances such as state of the property of the testator, state of his relations with his family, and many more such circumstances shall be considered while interpreting or construing the intention of the testator under his or her will. And lastly, where apparently conflicting dispositions can be reconciled by giving full effect to every word, such construction should be constructed. So, wherever there are contradictory dispositions, maximum way is to apply the golden rule and give effect to all of those dispositions. However, if not possible, at least the one which is apparent with the intention of the testator should at least be effectuated. So all of this is how we theoretically from section 82 to 88 of Indian Succession Act see the construction of a will along with certain illustrations and with the case laws where we find the actual practical ways of constructing a will. So this is all from my side on the part of will or chapter 6 of Indian Succession Act. Thank you.